Okay, we're talking about land titles today. There seems to be a lot of interest in land titles. My other videos that talk about land titles have got a lot of hits, and so we're going to go into this quite a bit more. This is going to be a bit lengthy, but not as long as some, and but it will go into a lot more detail. So we're all products of the government's educational system. The government has taught us what we need to know to operate in their system, but have they taught us everything? This is Book 73 of Corpus Juris Secundum, Section 13, page 181. Quote, "The right to own and manage property is a natural, unalienable right. Perfect ownership is the right to use and dispose of one's own property in the most unlimited manner, and nothing prevents an owner from dismembering his property and from disposing of each separate dismemberment as he pleases." And this is actually taken from in 1820 they passed an act. This is an act making further provision for the sale of the public lands, and this is very interesting because this was passed in 1860. And in Section 2 it says, "And be it further enacted that credit shall not be allowed for the purchase money on the sale of any public lands which shall be sold." And there was a specific reason for this, and this next slide explains it. This is a quote from Senator King of New York in March of 1820 during the passage of the act. And it says, "It was calculated to plant in the new country a population of independent, unembarrassed freeholders, that it would place in every man the power to purchase a freehold, the price of which could be cleared in 3 years, that it would cut up speculation and monopoly, that it would prevent the accumulation of alarming debt, which experience proved never would and never could be paid." And so that was back when we had some decent people in Congress. It would be nice to have a few of those around today. There are a few, but there's more crooks than there is the honorable ones. This is a court case. This is Supreme Court, 1863. "We are then to regard the revolution and these acts of assembly as emancipating every acre of the soil of Pennsylvania from the grand characteristic of the feudal system, even as to the lands held by the proprietaries themselves. They held them as other citizens did under the Commonwealth, and that by a title purely allodial. All our lands are held immediately or immediately of the state by the titles purged of all the rubbish of the Dark Ages, excepting only the feudal names of things not any longer feudal." And he goes on and says, "Under the acts of the assembly I have alluded to, the state became the proprietor of all lands, but instead of giving them like a feudal lord to an enslaved tenantry, she has sold them for the best price she could get, and conferred on the purchaser the same absolute estate she held herself, and these have been reserved as everything else has been granted by contract." Okay, so what they're saying is you have absolute title just like the government has absolute title, and that's exactly what they're talking about. This is 1839 court case. "After the American Revolution, lands in this state became allodial, subject to no tenure nor to any services incident thereto." Now, if you think about it, tenure and services, I mean, if you're paying property taxes, that's servicing, and tenure means that you're a tenant. I mean, that's one of the things they ask you. How do you want title vested? Do you want joint tenants or tenants in common? Well, tenant is the operative word. You're a renter. And so it's all a feudal system these days, but it doesn't have to be. And once you understand how to do it, it's not that difficult, although every county is going to be a little different, and because there's varying degrees of corruption. This is actually that same court case. Yes, no, it's actually a different one. 1837. "From what source does the title to the land derive from a government spring? In arbitrary governments, from the supreme head, be he the emperor, king, or potentate, or by whatever name he is known. In a republic, from the law making or authorizing to be made the grant or sale. In the first case, the party looks alone to his letters patent. In the second, to the law, and the evidence of the acts necessary to be done under the law, to a perfection of his grant, donation, or purchase. The law alone must be the foundation from whence the authority is drawn, and there can be no other source." Okay, so Do you live in the republic or do you live in the democracy? And that's the question. And you can be in either. This is actually that same court case as the last one, McConnell versus Wilcox. The land patent is the minument of title, such title being absolute in its nature, making the sovereign's absolute freehold on their lands. Finally, the patent is the only evidence of a legal fee simple title. And so that's McConnell versus Wilcox, Illinois, 1837. This is an act that was passed. This is an act to secure homesteads to actual settlers on the public domain. And this is passed in 1862. It says here in Section 2, it says, and be it further enacted that the person applying for the benefit of this act shall, upon application to the Register of the Land Office in which he or she is about to make such entry, make affidavit before said register or receiver that he or she is the head of the family or 21 years or more of age, and the purchaser shall acquire the absolute title by the purchase and be entitled to a patent of the United States on payment of the office fees and sum of money herein specified. Okay, so the operative word here is absolute title. Okay, and we're going to learn a little bit more about what absolute title is. And remember, we talked about that. It's the same title the government has. Okay, so it's total and free ownership. It's absolute ownership. Anyways, this is that same act, and it says, Section 4, it says, be further enacted that no lands acquired under such provisions as this act shall in any event become liable to the satisfaction of any debt or debts contracted prior to the issuing of the patent therefore. Okay, so think about it. What they're saying is that nobody, you buy this land and no creditor can come after your land to satisfy the debt. And that's when you have absolute title. And if you really understand what absolute title is, they cannot touch that land. Nobody can touch that land. You are literally king on that piece of land. And there's court cases to say there's three sovereigns in America. There's the federal government, the state government, and the people. And so then you would be one of the people as a sovereign on your land. And that's exactly what that's intended. And so that was back when we had some decent people in Congress. So this is Black's Law Dictionary, 6th edition. Absolute title is common law classification. An absolute estate is a full and complete estate, or an estate in lands not subject to be defeated upon any condition. Well, and think about it. If they're getting property taxes, then what do? If you don't pay the property taxes? They sell the land out from underneath you. Okay, that's what they do to tenants. It's actually called an unlawful detainder action. And that's for tenants. Allodial is free, not holding of any lord or superior, owned without obligation of vassalage or fealty, the opposite of feudal. Allodium is land held absolutely in one's own right and not of any lord or superior, land not subject to feudal duties or burdens, an estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. And so that's an allodium. Okay, and so again, if you're paying property taxes, that's a duty. Okay, and that's actually a feudal duty. It's a duty. It's absolutely. Allodium estates. This is Bouvier's Law Dictionary, 1856 edition. Signifies an absolute estate of inheritance in contradistinction to a feud. Okay, so there's either one or the other. Okay, there's nothing in between. Allodial, this is Black's Law Dictionary, 5th edition, free, not holding of any lord or superior, owned without obligation or vassalage or fealty, opposite of feudal. Okay, here they're talking about vassals. So people that are paying property taxes are vassals. Okay, allodium, land held absolutely in one's own right and not of any lord or superior, land not subject to feudal duties or burdens, an estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. Absolute title, is Black's Law Dictionary, 5th edition again. As applied to the land, an exclusive title. Okay, there's another word that we need to look at, or at least a title which excludes all others not compatible with it. An absolute title of land cannot exist at the same time in different persons or in different governments. That's Black's Law Dictionary, 5th edition. Exclusive right. An exclusive right is one which only the grantee thereof can exercise, and from which all others are prohibited and or shut out. That's Black's Law Dictionary, 5th edition. And this is taken from Book 23, American Jurisprudence, 2nd edition, fee simple or fee simple absolute, in Section 10. Quote, since an estate in fee simple implies absolute sovereignty over the land, the power of alienation is necessarily and inseparably incidental thereto, and an unlimited condition in restraint of alienation attached to such estate is void. So let's analyze that a little bit. Since an estate in fee simple implies absolute sovereignty over the land, the power of alienation is necessarily and inseparably incidental thereto. Okay, so you have a complete control over alienation and an unlimited condition in restraint of alienation. So in other words, if someone tries to alienate it for you, it's void. Okay, so again, if somebody stole your land based on property taxes, that's what this is saying, is that it's void. That's the reason if in Texas, I can tell you, and other places that I've seen, if they sell your land based on a property tax lien, what they'll do is they'll do a quitclaim deed. And what that is we'll talk about that, but it's basically the Brooklyn Bridge has been sold a whole bunch of times, and the way it's been sold, Brooklyn Bridge is owned by the state of New York, and the Brooklyn Bridge, the way they sell it is I sell my interest in the bridge. I may not have an interest, but whatever interest I have, I sell. It's quite a little, this is stuff the lawyers come up with, eh? They come up with this stuff. Anyway, so property taxes in America were started in 1861 under Chapter looks like 45, an act to provide increased revenue for imports. Yeah, get a load of that, eh? To pay interest on the public debt and for other purposes. And it's actually a direct tax. And it's in the 37th Congress, 1861. And we'll go into some of the text of that act. Here's one part of it. It says, be it further enacted that for the purpose of assessing the above tax and collecting the same, the President of the United States be and is hereby authorized to divide respectively states and territories, United States and the District of Columbia into convenient collection districts, and to nominate and by and with advice of the Senate to appoint an assessor and a collector for each such district, who shall be freeholders and residents within the same. Okay, so that's where the assessor and collector came from, the tax assessor. And be it further enacted that any person owning, possessing, or having the care, management of property liable to a direct tax, okay, so it's a direct tax, as aforesaid, shall not be prepared to exhibit a written list when required, as aforesaid, shall consent to disclose the particulars. Basically, it talks shall be received as the list of such person. Okay, so basically, any person owning, possessing, or having care, management of property liable to a direct tax. So they're talking about the tax assessor, and with their improvements, and in that case, it shall be the duty of the officer to make such a list, right? So then the tax assessor is supposed to make a list, which, being distinctly read and consented to, shall be received as such, as the list of such person. So they just make the list for you. That's what they do, and it's for a person. Remember that. Be it further enacted that the lists aforesaid shall be taken with reference to the day fixed for that purpose by this act, as aforesaid, and the assistant assessors, respectively, after collecting the said list, shall proceed to arrange the same and to make two general lists. The first shall exhibit in alphabetical order the names of all persons liable to pay a tax. And so again, it's all for persons, together with the value assessment, objects liable to taxation within such district. For each such person is liable, and whenever so required by the assessor, the amount of direct tax payable by each person on such objects under state laws imposing direct taxes. And so what they're saying here is back before the 14th Amendment. No, I'm sorry, before the 16th Amendment. Before the 16th Amendment, the only way the government could collect any money was through the states. Okay, the states had to collect the money and then pay it over to the federal government. And after the 16th Amendment, the government could collect it directly. And so what they're saying here, that's why it was under state laws. They had to pass state laws that enforced this act. And so that's why you see, you know, these property tax assessors done under state laws. And prior to the 16th Amendment, there was all the federal government, the only money the federal government got was from the states or from tariffs. Okay, that was about it. The only way they got any money was from tariffs or fees or from the states. And this property tax was the way they did it. And be it further enacted that as soon as the said Board of Assessors shall have completed the adjustment and equalization of the valuation. See, remember, I mean, I don't know how many you guys have seen this, but they have an equalization board in every county. Is hereby enacted and declared that the valuation, assessment, equalization on an apportionment made to said Board of Assessors, as aforesaid, shall be and remain in full force and operation for laying and levying, collecting yearly and every year the annual direct tax by this act, late and imposed, until altered, modified, or abolished by law. And here's another part. This is all in Section 2, by the way. Be it further enacted that there shall be allowed to the collectors appointed under this act in full compensation a commission of 4%, so they get a royalty. So they just basically put it's IRS is what it is. This is an extension of the IRS, and they get a royalty. And who knows what it is today, but back in 1862 it was 4%. Be it further enacted that each and every collector as deputy shall exercise or be guilty of any extortion or oppression under color of this act, as shall be liable. Okay, so again, this is part of where Title 18 United States Code Section 241 and 242 came from, because it talks about violating your rights under the color of law. So then this is in 1871. Chapter 71, an act prescribing the form of enacting and resolving clauses of acts and resolutions of Congress. Okay, so this is basically how they were going to definitions. This is a definitions act. And be it further enacted that in all acts hereinafter passed, the word person may extend and be applied to bodies politic and corporate. So they're saying that the word person is only bodies politic and corporate. That's exactly what they're saying here. An act concerning the construction of statutes in 1852 in the Legislative Assembly in New Mexico. The reason I'm mentioning this, it's actually in, you can find similar things in a lot of states. The reason I'm mentioning this, the reason I have it, is because I actually have a case in the U.S. Court of Appeals for the Ninth Circuit right now over some land in Arizona, and over property taxes, and quite frankly, you know, I hope they're listening, because I don't care what they do. I'm going to appeal it anyways. And so, according to Arizona was once part of New Mexico, and so this was in New Mexico statutes, and this is all in the submissions that I submitted to the clerks masquerading as judges on the court. Which was approved January 2nd, 1852, Legislative Assembly of the Territory of New Mexico, first day of December. Be it enacted, Legislative Assembly of the Territory of New Mexico, that the construction of the statutes of this territory, the following rules should be observed. The word person may be extended to bodies politic and corporate. In other words, it is bodies politic and corporate. Chapter looks like 56. An act to provide a temporary government for the territory of Arizona and for other purposes. So this is in 1863. This is when they split off Arizona from New Mexico, and then basically it says, together with all legislative enactments of the territory of New Mexico not inconsistent with the provisions of this act are hereby extended to and continue to be enforced in said territory of Arizona. So they're basically saying that act that we just talked about in New Mexico still applies in Arizona. And then if you go and look in 26 U.S.C. 7701, when using this title were not otherwise distinctly expressed or manifestly incompatible with the intent thereof, the term person shall be construed to mean and include an individual, trust, estate, partnership, association, company, or corporation. And so what they're saying is that it's all fictitious entities under a justum generis. When we go into color of law, there's a color of law presentation that we're going to be doing here, and we're going to go into this in more depth. But a person, when they list a bunch of things under a justum generis, then individual, because they're listing a bunch of fictitious entities, then an individual is also a fictitious entity. If you register your land, you're essentially giving your land to them. You can record your land if you choose, but that is not a gift. We need to train our government bureaucrats. Real property, this is taken from Bouvier's Law Dictionary, 1856 edition. In the underlying portion, in order to make one's interest in land, real estate, it must be an interest, not less than party's life, because the term of years, even for 1,000 years, perpetually renewable, is a mere personal estate. Okay, so think about it. There's a difference between real property and real estate. And the reason it's called an estate is like your father's estate. You have an interest in your father's estate, but you don't own it. That's why they call it real estate. You don't own it. You just have an interest in it. Real property is something you own. And so the question you have to ask yourself is, do you own your land? And you can. Real property, land and everything is attached to the land. Real estate is real property that you have an interest in, but you do not own it. Estate is the operative word, and estate is something you have an interest in, but you do not own, like your father's estate. A title. A title is defined by Lord Coke to be the means whereby the owner of lands hath just possession of his property. This is the definition, title of lands only, and we're going to go through several kinds of title. And so over the next couple slides, we're going to talk about that. Anyways, in section 3, it says the title is either good, marketable, doubtful, or bad. There's 4 kinds of title, and that is it. Okay? Good, marketable, doubtful, or bad. That's it. And so a marketable title is one which the court of equity considers to be so clear that it will force an acceptance by a purchaser. And so that's what a marketable title is. If you get a mortgage on something, it's going to have a marketable title. And a court of equity, okay, you got to understand that's when the bankster thieves foreclose on your property, they always go into a court of equity because they don't really have title, okay? They just have an equitable interest in the property because technically whoever has the name on the property is the one that owns it. And so there's 2 kinds of ownership. There's legal ownership and equitable ownership, and so illegal and equitable title, and the guy that has the land in his name is the legal owner, and then but the banks, if there's a mortgage on it, they have an equitable interest. And so and there's even statutes that talk about that. I think we talk about that more in. We've talked about it in other presentations. I can't remember one off the top of my head. But the doctrine of marketable title is purely equitable and modern orange. At law, every title not bad is marketable. Okay, so then if you think about it, if we go back to these 4 kinds of title, whoops, right there, a title is either good, marketable, doubtful, or bad. If it's not bad, then it's marketable. So good, marketable, and doubtful are all marketable. These bankster thieves just want to loan out the money. Actually, when you understand what happens is they basically loan your own credit. They've created it out of nothing. The doctrine of marketable titles is purely, well, I already read that. At common law, doubtful titles are unknown. Every title must be either good or bad. So at common law, it's either good or bad, and that's it. A bad title is one which conveys no property to the purchaser of an estate. Okay, and so that's, a good example is a quitclaim deed. Okay, remember we were talking about that a minute ago? Quitclaim deed is where the Brooklyn Bridge got sold. Well, the state of New York owns the Brooklyn Bridge, and so anybody that bought the Brooklyn Bridge didn't buy much, and so they would say that they got a bad title. Title to real estate is acquired by 2 methods, namely by descent and by purchase, and that's true. Okay, so in other words, it's either passed on through your family or you buy it. Land titles come in various forms. There's a general warranty deed, special warranty deed, sheriff's deed, judicial deed, quitclaim deed, and a land patent. We're going to talk about all of those. The general warranty deed is where the seller warrants the title to be free of all liens and encumbrances. It is generally received in order to get a mortgage before the bank will authorize the mortgage, and it's considered marketable title. Special warranty deed is where the warrant the land to be free on all liens and encumbrances with some reservations. Okay, and is usually used when the land has been the subject of a foreclosure or tax sale. And so like the bankster thieves like to use special warranty deeds all the time, because then technically they're not completely liable. If you sued them and you had all your ducks in a row and knew what you were doing, your remedy wouldn't be as severe as if they give you a general warranty deed. And a special warranty deed is considered marketable title. Sheriff's deed is when the sheriff sells a piece of property, and it could be a foreclosure or tax sale or something like that, and it's considered marketable title. Judicial deed is when a judge orders the property sold, and it's considered marketable title. Quitclaim deed essentially says that the seller transfers his interest in a piece of property. Property sold because of a tax sale can be transferred by quitclaim deed. That's what I've seen in Texas. Quitclaim deed can transfer a title as effectively as a general warranty deed. It can. A lot of times in a family, remember we talked about how the title can be passed by descent? Well, I've seen it where a grandfather would pass it on to his grandson, just give him a quitclaim deed, and and then basically, he lives on it, and he basically, after 7 years, he's got squatter's rights anyways. A quitclaim deed may transfer nothing. Okay, a quitclaim deed can transfer a title as effectively as a general warranty deed, and it may transfer nothing. A quitclaim deed, this is Black's Law Dictionary 6th edition, a deed of conveyance operating by way of release that is intended to pass any title, interest, or claim which the grantor may have in the premises. Color and appearance or semblance or simulacrum as distinguished from that which is real, a prima facie or apparent right, hence a deceptive appearance, a plausible assumed exterior, concealing a lack of reality, a disguise or a pretext. That's Black's 5th. Color of bull, that which in appearance only, not in reality, what it purports to be, hint, counterfeit, feigned, having the appearance of truth. Color of law, the appearance or semblance without the substance of legal right, misuse of power possessed by virtue of state law, made possible only because wrongdoer is clothed with authority. A state is action taken under color of law. These deeds include the ones as follows: a warranty deed, quitclaim deed, sheriff's deed, trustee's deed, judicial deed, tax deed, will, or any other instrument that purportedly conveys the title. Each of these documents state that it conveys the ownership to the land. Each of these, however, is actually a color of title. And that's taken from Title to Real Property, Preparation and Examination of Abstracts, Chapter 3, Section 73, page 93, and it was in 1919. So anyways, all of those are color of title. When we say a person has a color of title, whatever may be the meaning of the phrase, we express the idea at least that the act has been previously done by which some title, good or bad, to a parcel of land of definite extent has been conveyed to him. And that's a Missouri court case, 1816. There, the complainant seems to have relied upon the tax deed as conveying to him the fee, and to sustain such a bill, it was incumbent to him of him to show that all the requirements of the law had been complied with. Okay, so think about it. What the court is saying here is that, first of all, when you get any kind of deed, it's a color of title, and it's always caveat emptor, right? That's buyer beware. And so when you go and pay that, he paid a tax deed, and Hulls versus Bunton, okay, Hulls probably was the guy that owned the land, and he understood the law, and so then the tax assessor basically sold the land up under Hulls, and Bunton's the guy that bought it, or thought he bought it, and this is the court case, and the judge is saying that Bunton bought nothing. That's exactly what he said. The incumbent, it says incumbent, to sustain such a bill, it was incumbent on him to show that all the requirements of the law had been complied with. Obviously, he's saying that he hadn't shown it. And so, whenever I buy land, that's one of the first things I ask them, is this the subject of a tax sale or foreclosure? Because I want nothing to do with it. They stole that land. Clipping, this is another court case, Clemmings versus Dolan. 1909, authorities hold that to render a title marketable is not only necessary that it be free from reasonable doubt. In other words, that the purchaser is not entitled to demand a title absolutely free from every possible suspicion. Okay, again, remember, there's good, marketable, questionable, and bad, right? I think is what the four were. And so the questionable, I mean, that can still be marketable. A patent to land issued by the United States under authority of law is the highest evidence of title, something upon which its holder can rely for peace and security for his possession. It is conclusive evidence of title against the United States and all the world. And that's the American law of mining. And so, yeah, a land patent. Nothing but a patent passes a perfect and consummate title. A patent issued by the government of the United States is legal and conclusive evidence of title to the land described therein. No equitable interest, however strong to land described in such a patent, can prevail at law against the patent member. It's talking about that in that 1862 Act, right? It said basically that nobody can come after the owner based on for anything, for any debt. Okay, so that's an equitable interest. Any kind of debt is equity. That's all equity. And so any kind of debt, if you bring forward your land patent, technically, you know, if we didn't have a bunch of bankster thieves, the government's owned and operated by the bankster thieves, technically what you could do is bring forward the land patent on your land, and it wouldn't matter about the mortgage. You know, the mortgage would technically be on the house, so they could come and take the house, but they better get it off my land here in 30 days. But the reality is something completely different. And so so what? I don't even try doing. Well, I still bring forward a land patent, but you know, to try and sue them in court and all the rest of it, you know, your chances are slim to best, unless you know, because they're all courts of equity, and they prejudge it. They're actually clerks, okay, and they're working for the bankster thieves, and so you know, it's really difficult to get a decent remedy against these bankster thieves, and so you know, I don't, you know, go that way. But you can certainly cloud that title. If you bring forward a land patent, you can cloud that title in a major way. Matter of fact, in Texas here, there's some kind of recorders that if you try and do that stuff, they won't even record it. And that tells me that it's really powerful. And so, because they're prepared to perjure their oath to help the bankster thieves, okay? And so, again, we need to administer these counter recorders and bring them to justice. A patent is the highest evidence of title and is conclusive against the government and all claiming all under junior patents or titles until it is set aside or annulled by some judicial tribunal. That's U.S. Supreme Court. Issuance of a government patent granting title to land is the most accredited type of conveyance known to our law. And a patent is intended to quiet title to and secure the enjoyment of the land for the patentees and their successors, thus as a quitclaim deed. Get a load of that, eh? A land patent conveys whatever interest the government has in the soil and the land. Think about it. Why is the government issuing, why is a land patent a quitclaim deed? Well, think about it. Who was here first? And the First Nations people were here first, so technically it's their land. The government stole it from them. As we have noted in connection with a patent by the United States, a patent's effect is the same as though the United States had executed a quitclaim deed. And that's U.S. Supreme Court. A patent operates as a deed of the government. As a deed, its operation is that of a quitclaim. It passes only the title the government has on the date of the patent. And so, again, what happens is that it's actually a pretty good title. Even though the government stole the land, the only remedy is to go before their clerks and try and get a remedy, and their clerks, you know, are bought and paid for. A patent of the United States as a deed in operation is that of a quitclaim, or rather a conveyance of such interest of the United States as the United States possessed in the land. And again, that's quoting a U.S. Supreme Court case, but it's also, the actual site is in, no, that's the U.S. Supreme Court case. A land patent is the highest and best title, but at the same time, it's a quitclaim deed. If a land patent is a callable title, then what would be a true loaded title? It'd be, there is nothing here requiring a deed to establish a color of title, and under the former decisions of this court, color of title may exist without a deed. That's true. And that's called squatters' rights. That's true. All you got to do is live on the land for 7 years. I mean, that's, in the old days when the people used to homestead, that was the deal, is you go and live on the land for 7 years, and then they just give you a land patent because you owned it. That's squatters' rights. The courts have ruled that the government has to settle the land claims of the original people. They're essentially saying that the government stole our land. Now, there's different words for the original people. They could be called First Nations. They could be a friend of mine that's involved with them. He calls them Anishinaabe. Anishinaabe. And so I guess that's what they call themselves. I'm not sure. But certainly Indian. I mean, they're not Indians. Indians are people from India. And so, you know, that's certainly not appropriate. Anyways, this is a crown patent from Canada. Notice it's in a box. That's because they know it's a fraud, and if you sue them over it, or somebody sued them over it, you know, there's nothing on that piece of paper. That's exactly what it is. There's nothing on that piece of paper. This is a U.S. patent, and let's see, shoot, I guess I didn't include the rest of it, but the text on a U.S. patent is, this is the text from a U.S. patent, and it basically says, and granted by these presents does give and grant unto said Santa Pacific Railroad Company, successor in interest, to the Atlantic and Pacific Railroad Company and to his successors and assigns the tracts of land listed as aforesaid and described in the foregoing, to have and to hold the said tracts and the appurtenances thereof unto the Santa Fe Pacific Railroad Company, successor as aforesaid, and to its successors and assigns forever. Okay, that's the text. And then it goes here, and it says that it's signed by Woodrow Wilson in 1915. And so the point is, that's all that's on there as far as text. These are particular patent. The reason I didn't put it on here is because it's a list of sections. It's one of these patents where these railroad companies were granted 10 miles of land on either side of the railroad wherever they went to pay for the expense of putting the railroad in. And so so this was just a list of sections of land, you know, so much, this section, township, range, and it was sections of land. And so this was just it was like about a 4-page list. And so the point is it doesn't say anything in there. I don't see anything about property taxes. I don't see anything in there about easements. I don't see anything in there about mineral rights. I don't see anything in there about anything. Okay, and this is absolute ownership right there. That's what that is absolute ownership. And this is the text that Woodrow Wilson signed, and it says, President of the United States of America has and caused these letters to be made patent in the seal of the General Land Office hereunto affixed, given under my hand, the city of Washington, 2nd day of December, in the year of our Lord 1915, independence of the United States, the 140th year. And so again, notice that all the numbers are spelled out. They're not, you know, except the patent number, okay, is 501639. But the numbers like December the 15th, it's FIFTEEN, that's common law, okay. These Greek numbers that you see at the bottom, that patent number, I mean, that's not common law, okay. The way at common law things are done is they're all spelled out. Recent land patents are inside a box. They know they have no authority. It says the land's granted to John Smith, his heirs and or assigns forever. All crown patents that I've seen always reserve something, mineral rights, trees or something. It says nothing about property taxes, says nothing about easements, says nothing about eminent domain, zoning rules, regulations, says nothing about any of that. Sometimes they reserve mineral rights. Other than mineral rights, there are no reservations. I've got some U.S. patents for some land that I have out in West Texas, and it reserves mineral rights. A usufruct is civil law, the right of enjoying a thing, the property of which is vested in another, and to draw the same all the profit, utility, and advantage. That's Bouvier's Law Dictionary, 1856 edition. A usufruct is a type of a trust. And if you go through my Bankster Thieves 1 and 2 videos, I go through what how Federal Reserve notes or Bank of Canada notes or IOUs, and how what that does. If you think about it, when you give someone an IOU, you're essentially saying that some guy promised to pay me, and when he pays me, I'll pay you. Well, by definition, that creates trust. And so that's a constructive trust. And so what happens is that's why they spell your name in all block capital letters. The forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They form a part of the public debt of the United States, the validity of which is solemnly established by the so-called 14th Amendment, and that's the U.S. Supreme Court. And so these Bank of Canada notes or Federal Reserve notes or IOUs, they're commercial paper. When you pay for land with a bank note, it is not paid for. Think about it. You didn't pay for it. You just said you're going to pay for it. Even if you pay cash, because you didn't get paid. How can you possibly pay for something that you didn't get paid? How do you pay a debt with a debt? You can't. A trust is created. Eminent domain. That's why the government has eminent domain. You basically, what you do is when you use their banknotes. I mean, think about it. This is one thing I go through in the Bankster Thieves videos. I show how Federal Reserve notes or Bank of Canada notes. They're all they're IOUs and they're bills of credit. Right? Think about it. It's exactly what they are. They're bills of credit. So the Federal Reserve issues this bill that's saying that the United States has $1 in credit. And so then when you pay for something with a bill of credit, then what happens is, who owns it? You don't own it. The government owns it. The United States owns it because you just bought it on their credit. That's exactly what happens. So then you buy it on their credit, then they own it. That's why the government has eminent domain, and that's why they're charging you property taxes, and that's why by paying for the land with their commercial paper, you just gave it back to them. It's exactly what happened. Have you ever seen a road that goes along straight line when it comes to some guy's land? It turns and goes around the outside of the land, and then once it gets around the land, then it continues going straight. That's because all of those landowners didn't really own the land except for the guy whose land they went around. They went and had eminent domain on all the other ones. There's Spanish land grants in Arizona. I know people in Arizona who've had land in their family for generations, and they do not pay property taxes, never have. They just pass it on from father to son. I've heard of people in Canada who, when they inquire about their land, the response is the land titles has no jurisdiction. And again, if you have absolute ownership of your land, they got nothing to say to you. Federal Reserve notes or Bank of Canada notes or IOUs is found in the Banks of Thieves 1 and 2 videos. There's a distinction between a debt discharged and one paid. When discharged, the debt still exists, though divested of its character as a legal obligation during the operation of the discharge. So that's what they're saying. When you discharge a debt, which is what you do with a Bank of Canada note or a Federal Reserve note, that debt still exists. Okay, they just can't come after you for it, but that debt still exists. Evidence of your usufruct, they call it real estate. You pay a yearly rent. They can take it away from you, and if they can take it away from you, then you do not own it. Your land has easements. Your land is subject to zoning rules and regulations. If you pay for land with an IOU, it creates a trust. The way you defeat the trust is you have to pay for the land with gold or silver coin or a bill of exchange, something valid, okay, like labor. I've heard of people paying for things with labor, do a bill of exchange, but you have to say it on the deed. How can you have true allodial title to land? You bring forward all the rights and privileges of the original land patent. You pay for your land with gold or silver coin. At common law, our numbers are spelled out, so you make sure and spell out all those numbers. And you get a meets and bounds legal description, okay? And so what happens is when you get, most land nowadays, or a lot of land, especially in a city, is in some subdivision. So it'll be lot 1 of some rancho subdivision. And so you're going to have to get a surveyor to come out and give you a meets and bounds legal description. I guarantee you they know what you're talking about. And what they'll do is they'll get they'll find the nearest survey marker, and they'll say, you go 150 feet northwest of this nearest survey marker, and that's the northeast corner of the property, and then you go south 50 feet, and then you go east, and then they basically describe the legal description, okay? And so that's a meets and bounds legal description. It's not just lot 1 of some subdivision. A patent from the original people would trump any other patent, and I know people that do that, and it does. Matter of fact, there's a guy in BC that I heard about, British Columbia, that went and he proved that bankster thieves were foreclosing on his land, on his property, and he proved that the Crown was only granted 400 acres in British Columbia in the foreclosure hearing, and the court threw it out. And so, because it made his Crown patent invalid, because the Crown didn't have the authority to grant that patent, and so then he was just basically a squatter on this land, and he'd been there for more than 7 years. So the court threw it out. The bankster thieves didn't have a leg to stand on. Because almost everything is done these days with commercial paper, the courts presume that commercial paper was used. You can defeat their presumption by putting on the document the type of payment that was received, gold or silver coin, or labor. Bill of exchange, this is an example of one. Upon receipt of 20 each, 1 troy ounce pieces of pure silver each, I do hereby grant and exchange to John Henry, House of Smith, this land together with all the rights and privileges of the original land patent number 123456, a true copy of which is attached here too, all of which is incorporated herein by reference in its entirety. That's basically what mine say when I do them. When you get true allodial title, you do not have to tell them that you purchased your land. If you purchase or bought your land, that's a commercial transaction. You tell them you converted some silver or gold to land, and I've seen court cases that talk about it. Conversion's common law. This is the Indian Act of Canada. this is, you know, these crooks, you know, that they basically, it says in this act surrendered land. So they're saying that the First Nations surrendered it. Yeah, right. I'll bet they did. In this act, surrendered lands means a reserve or part of a reserve or any interest therein, the legal title of which remains vested in the bitch that has been released or surrendered by the band for whose use and benefit it was set apart. And this is the Prize Act, subject to any orders or regulations. See, that's exactly what they're doing, is they're operating under prize. They're stealing it. And the court shall exercise its prize jurisdiction in respect of all persons, matters, and things. Okay, so that's exactly what they're doing. And so that's, but they don't want to admit it. They're a bunch of liars and thieves. They're pirates, really, is what they are. Once you understand what's going on, especially in Canada, they're the worst. Some jurisdictions have land transfer, tax, or an affidavit of property value. If you pay the tax or provide the affidavit, then you're putting your property in the tax rolls. This is perfect if you think about it, because what you do is you serve the instrument on them by registered mail, and they return it to you saying that it's not recorded, but it's in a special file. Well, that's perfect. That's the non-tax-paying file. Some counties require it to be a land title document before you can record it. It's easy to make any document a land title document by inserting in the top right corner of the front page the following information. And you're going to have to go to the county recorder's office or the planning. Depends on where you live. You might already know the section, township, and range, but if you live in a city, in a house where you're basically, you can spit to the neighbor, then you ought to go to the city planning department. They'll have a big map on the wall and ask them what township, section, township, and range you're in, and they'll tell you. They'll usually have a big map on the wall, and it's got all the sections marked, and you can find your house in that, and you'll be able to tell what section it's in, and which township and range, and then and where it's all taken from, and so and then you just put it in there. And an instrument is deemed in law filed at the time it's delivered to the clerk, regardless of whether the instrument is file marked. And so I don't care. That's why I sent it to them by registered mail, because I got proof they got it. And then they invariably sent it back to me, and so that's further proof. And so I have proof they got it. They're saying they put it in that special file, and they know. And but when you fill out that affidavit of property value, that's denominated in Federal Reserve notes, so you're saying that you paid Federal Reserve notes, and that'll bring you back in the system. Or land transfer tax, it'd be the same thing. It's only corporations that have to pay the tax. So if you pay the tax, you're saying you're a corporation. Remember, they only accept Bank of Canada notes or Federal Reserve notes. So think about it. A Bank of Canada notes is an IOU, and remember in the Bankster Thieves videos, it says that under the Gold Reserve Act of 1934 that those banknotes are only meant for internal use of the government. Okay, the money of we the people is gold or silver coin. That's the only way at common law. Only gold or silver coin is lawful money at common law, and. The King of England held ownership of land under a different title with far greater powers than any of his subjects. Though the people of England held fee simple titles to the land, the king actually owned all the land in England through his allodial title. Though all the land was in the feudal system, none of the fee simple titles were of equal weight and dignity with the king's title, the land always remaining allodial in favor of the king. So, now remember that one of those first court cases I read was a Pennsylvania case where it said that you got the same title the state has. Okay, so it's by contract. And so positive law is law actually and specifically adopted by proper authority for the government of an organized jural society, and this is actually the Office of Law Revision Counsel. The reason I'm mentioning this is that it's important as far as land titles are concerned. If you look down in the highlighted part, it says the following titles of the code have been enacted into positive law, and that's actually about half of the titles of the United States Code. When Congress enacts an act as positive law, they enact the code as a statute. Okay, so United States Code is basically where they go through all the statutes at large. You can have a bunch of bar members. Okay, watch my bar member videos and you'll know what I think of bar members. But you have a bunch of bar members that sit in a room and they go through all the codes and all the statutes, okay, because there's courts that say that if there's a difference between the statutes at large and the code, the statutes prevail. So you have a bunch of lawyers or bar members that sit in a room and go through all of these statutes and put it into a code, make it into a code. And so, but sometimes Congress has actually taken that code and enacted the actual code as positive law. And so the reason that's important is because when they do that, they have to repeal all of those statutes that it replaces. And that's what we'll go through right now. This is actually taken in 1947 when they enacted Title I as positive law, and that's what the highlighted part up at the top there talks about. And then if you, this is the end of it, it says the sections or parts thereof of the statutes at large, provisions codified in this act are hereby repealed. Okay, so, and then there's that's better. It's the other one was, this is a close-in picture. And so then what happened, this is the list of acts that were repealed. And if you look there, it says the statutes at large are revised statutes, so they repealed a bunch of the statutes of the revised statutes, okay, which is basically some codes they repealed. That's the first part, and then it talks about an act of 1893. And so, in 1920, an act of March 6, 1920, Chapter 94, okay? And so then an act of 1928, okay? So there's a bunch of revised, these codes that they repealed, but there's some acts too, okay? And those are the actual acts that were passed by Congress. And so the point is, let's get in closer. And so the point is that the oldest thing that they repealed was 1893. And so then, if you go here, this is Title III, okay, and this is where it was the section that had the repealed stuff, right? And this is the list. The oldest one they repealed was in 1887, and so, and that's what that is. Oldest one they repealed is 1887, and so then this is for Title IV when it became positive law. And this is where it's repealed. And if you notice here, the oldest one that's repealed, okay, this other stuff at the top here, these are all revised, these are sections in the revised code, okay, that's what those are. And so then it says here where it says June 16th, 1936, and that's talking about an actual act, okay, and that act, okay, again is 1936. That was repealed. And so, and then this is Title VI, and this is where the list of repealed acts, and the oldest one that was repealed was 1895, and this is Title IX, and this is where it's repealed, and the oldest one, I mean, those are all 1925. And so then this is Title 17, and I'm certainly not going to go through all of them, but we'll go through a bunch of them here. And this is where the list of repealed stuff, and 1909 is the stuff that's repealed. And so then this is Title 18, and this is where the stuff is repealed. And the oldest one that's repealed is 1872. And the point I want to make is that there's nothing older than 1868 that I've seen repealed. And the reason I'm saying that is that in 1871 there was a corporation set up for the District of Columbia, and that's what's operating today. When the southern states walked out of Congress, the republic ceased to function, and the de jure Congress ceased to function, and everything's been operating under executive authority ever since. But the trust is still there, okay? If you go through my bankrupt corporate so-called governments presentation, then what happened is there's two entities. There's one that's a trust and there's one that's a corporation. There's no authorization to set up a corporation, so the corporation has nothing to do with we the people. That trust is still there. You can still get access to that trust and everything under it, and all of the acts up to the Civil War were passed by the trust. And all of those acts, none of those acts have been repealed, and they're still there, and you can have access to them. And so absolute title is, I know people who have land patents on their land and they pass it on in their family and have done that for generations, and they do not pay property taxes on it, and never have been contacted for any taxes. I currently own land that is not in any tax rolls. A lot of it depends on how corrupt the local government officials are. Property taxes are theft and a denial of due process. I currently have a case in the U.S. Court of Appeals for the Ninth Circuit. This is what is due process of law may be ascertained by examination of those settled usages and modes of proceedings existing in the common and statute law of England before the immigration of our ancestors. And the expressions due process of law and law of the land have the same meaning. The law intended by the Constitution is the common law that had come down to us from our forefathers as it existed and was understood and administered when that instrument was framed and adopted. It is manifest and not left to legislative power to enact any process which might be devised. The due process article is a restraint on the legislative as well as the executive and judicial powers, and cannot be so construed as to leave Congress free to make any due process of law by its mere will. In other words, they don't have authority to modify common law. Okay, common law is we the people. They don't have authority to modify it. I don't care if he's a judge. I don't care if it's Congress. I don't care who it is. They don't have authority to modify it. That's the reason that all these judges, when they're dealing with a statute, they cease to be a judge. They're now a clerk. And that's the reason there are no judges, because the only thing they deal with is statutes, and the burden's on you to bring up the issue. No legislator or judge or clerk can change or modify your right to due process or any common law right. That's why the courts have said that under a statute there are no judges, they're just clerks, as found in the J.D. Rook, the bought and paid for clerk masquerading as a judge video, and the de facto courts video, and the Fire of the United Nations Judicial Whores in Canada video, and the Corruption in the Courts 3 video, and the Corruption in the Courts 4 video. That's also why the courts have said that such clerks have no immunity and they are fully liable and their judgments are void judgments, as found in the upcoming void judgments video. It is my opinion that well over 90% of the people who work as peace officers are honest, hard-working people who are very patriotic and take their oaths of office very seriously. Many of them have not been properly trained. Many of them are under pressure to generate revenue. The burden's on us to educate them since their bosses are obviously not doing it. What can we do? We can lay a proper foundation so they cannot claim ignorance. Their biggest strength is in plausible deniability. We have to take that away from them. We can demand a common law court. We can know that a true common law court, what a true common law court is, so you can tell if they really give you a common law court. You can complain to the Judicial Council, which is basically a council of whores, to make sure you bring up the right issues. Complain to politicians. We need to work together to fire these Vatican Jesuit whores selling their justice. Make YouTube videos. Circulate them around far and wide. Send them to me. I'll circulate them. Realize it's never over until you say it's over. Never, ever, ever give up. Always remember, we the people are the ones who are really in control, not a gang of Vatican judicial whores selling their justice, not their hired thugs, not the Canada border pigs. Even a peace officer can do nothing that we ourselves cannot do. We can refuse to participate in their de facto system. We can educate ourselves about what a common law jury is and what the law of the land is. We can educate ourselves so we know when our rights are being violated. We can educate our public servants because many of them do not know any more than we do. We can educate other people by circulating this video and any other way possible. We can demand a common law jury of our peers. We can work with our friends and neighbors to reestablish our common law juries and our common law de jure courts. We can work with our friends and neighbors to give the United Nations, get the United Nations out of America and Canada and anywhere that wants to be free. United Nations is owned and operated by the bankster thieves and their Vatican handlers. Upcoming events: Color of Law, Fire the United Nations Judicial Whores in Texas, Fire the Fort Worth Pigs, Fire the Grand Prairie Pigs, Fire the How to Do a Habeas Corpus, Citizenship, Fire the United Nations Judicial Whores in America, and U.S. Border Pigs. And copies of these documents can be found at my private group at Yahoo called Administrating-Your-Public-Servants. I got YouTube videos. My profile is Sovereign Living. And you can send me an email, and I appreciate you taking the time to listen. I hope this has helped you. It's amazing what you can do once you understand the law and what to do. And I hope you have a real nice day.